Good afternoon, everyone. This is the House Ethics Panel meeting, the first meeting of 2021. I, for the record, am Betsy Ann Rask, Clerk of the House. I'm here with my co-counsel.
Mike O'Grady, Office of Legislative Counsel.
And the first order of business is to elect a chair of the panel. So we will now entertain motions, we will now entertain nominations for chair of the panel.
I would like to move to nominate John Gannon.
Representative Jessup has nominated Representative Gannon as chair. Are there any further nominations?
Does that need a second?
You may.
Seconded.
Representative Sebelius seconds. Are there any further nominations? All right, we will consider nominations closed. All those in favor of electing Representative Gannon, chair of the House Ethics Panel, please say aye.
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 Any opposed? Representative Gannon, the ayes have it. You are elected chair of the House Ethics Panel.
Thank you. Thank you, everyone. And first thing I want to do is apologize for the delay in getting this meeting scheduled. Part of it was due to the work I was doing on pensions. And then we unfortunately picked Thursday afternoons to attempt to have this meeting, and the floor ran long every Thursday that we scheduled it. I wish I had scheduled it for this Thursday because it was a very short session, but we didn't do that. So thank you all for bearing with me, and I apologize for that. So the first area of review is changes to the House ethics rules. And Betsy Ann will go through those. And once we get through that, we'll go through the panel modifications to the panel procedures, which are tied to the rule changes. This is just something, Brian, that we have discussed as a panel last year, but we want to review them again. And I anticipate that we will not send them to the Rules Committee this year, but wait until the beginning of the next session to do that, just because we are so close to the end of the session. So Betsy Ann, please.
Great, so thank you. Michael and I are going to tag team the first agenda item, which is to just give a high level overview of the current House rules regarding ethics and your current panel procedure. Is everyone okay with following along on their own computer screens rather than doing share screen, so we can all stay on together? Okay, so the first thing I will just review a high level overview of for you are the two current House rules in regard to ethics. The first one is House Rule 14A. That's the requirement that at the beginning of each biennium, every House member is to submit to the clerk's office a disclosure form that sets forth, to the best of the member's ability, information regarding any boards that they served on that are regulated by law, and whether they receive any form of remuneration for those, and their employer. The other applicable rule is House Rule 90B, which established this panel. House Rule 90B starts by saying that the House is opposed without qualification and prohibits violations of the Vermont Constitution and, quote, House rules standards of ethical behavior. And the policy covers reps and persons that either the Speaker's office or clerk's office employs. An ethics panel is to be appointed of 5 members. It's appointed by the House Rules Committee. Panel elects its chair, as you just did, and the panel has authority to adopt procedures to implement this policy and conduct its business and provide copies of the policy to all members. You also have a duty to advise members and provide training on ethical conduct for House members, including House Rule 75. That prohibits members from voting on questions in which they're immediately or directly interested. You also are required to receive and investigate complaints of alleged ethical violations made against members of the House, and you can recommend disciplinary action to the full House if you do think that an ethical violation has occurred. And then the rule goes on to say that this rule prohibits retaliation against a person who complains, reports, or cooperates in an investigation. And also you have an annual report that you need to provide to the House that describes the number of complaints filed, the disposition of those complaints, and the number of member requests for ethical advice. I'm going to turn it over to Michael now to review the panel procedure.
So as Betsy Ann noted, the rules require you to have or authorize you to have a procedure for how to handle complaints. The procedure provides that any person can file a complaint in writing with the panel regarding alleged unethical conduct that occurred during the current biennium. So it's only for the current biennium. The panel applies to all House members and the staff of the Speaker's office and the staff of the Clerk's office. When you receive a complaint, the panel meets to determine if there are reasonable grounds that an ethical violation occurred. If there are no reasonable grounds, then the complaint is closed, and that closure is confidential. If there are reasonable grounds, there is an investigation that goes forward by the panel. The investigation is confidential. It may include interviewing witnesses and collecting information and documents. There are 3 general outcomes of an investigation. You can determine that there is not enough evidence or no violation occurred. And at that point, you close the complaint and notify the complainant and the respondent. It should be noted that that type of complaint, the ones that are closed, may be reopened to show in the future to show a pattern of conduct by the respondent. The second potential outcome is that you enter a stipulation with the respondent regarding action that should take to address or remedy the situation. And then the third potential outcome is that you draft charges and set the matter for a hearing. And then both the respondent and the complainant are authorized to be at the hearing. They can have their own counsel with them. The panel itself may hire independent counsel, and the hearing is confidential. Unless the respondent asks that it be open to the public, you are not bound by the rules of evidence. The chair makes evidentiary rulings, and the burden of proof at a hearing is if there is clear and convincing evidence that an ethical violation occurred. If the panel finds an ethical violation did not occur, it dismisses the complaint and provides notice to the complainant and then the respondent. If there is an ethical violation, it introduces for the House's consideration a resolution of its findings and recommendations for disciplinary action. Again, the proceedings of the panel are confidential, and the records that it produces are not subject to the Public Records Act. And that is basically an overview of the procedure.
So the next thing we'll just review briefly is how the panel has been exercising this authority. You have access to the links of the past 2 panel reports. I'll just start with 2019 just to provide an overview, a refresher of how active this panel has been. You have been active. For the 2019 year, you had closed a complaint that you had received in 2018. That complaint had also been filed with the State Ethics Commission because the State Ethics Commission is directed to submit complaints to the entities that handle them and request reports back in the case of the House. That happened in that case. You received another complaint in the year 2019 and you closed that one, but reserved the ability to reopen it in the future. That again was referred to the Ethics Commission. And so the panel had given its final disposition to the Ethics Commission in that matter. Also in 2019, this panel contacted multiple House members whose candidate disclosure forms were not posted on the Secretary of State's website in accordance with a new law that was required for legislative candidates to file financial or disclosures with the Secretary of State's office as part of your candidate consent form. And thereafter, after contacting those panel members, you ensured that all members' forms were posted on the website as required. And then in 2019, the panel reported receiving 2 member requests for ethical advice. In 2020, the panel reported that it had 8 complaints. Those complaints were closed for various reasons. There were also some references to the Ethics Commission because complaints were also filed there. So this panel submitted its final disposition to the State Ethics Commission as requested under the ethics law. Also, in the year 2020, panel members reported receiving 5 House member requests for ethical advice. So now that the panel has been in existence for several years, more than several years, you've got some time under your belt to determine that you think that the panel has previously determined that there needed to be some changes to your rule. And then if those were to get adopted by the House, then you would accordingly propose some potential revisions to your procedure. So if you want to pull up the document that you have that discusses the potential revisions to your House rule, we can just go over that at high level now, just to refresh our memory, and for Representative Chena as a new member to go over on a high level review of what this panel in the past has thought should be some potential changes to its rules that you might propose to the House. So if you want to pull up that document that proposes potential revisions to your House Rule 90B, it would start out by clarifying with more specificity what it means to have standards of ethical conduct for the House, because that Rule 90B starts out by saying that the House is opposed to and prohibits violations of the Vermont Constitution and House rules standards of ethical behavior. First is there's a suggestion to just change it to ethical conduct. One of the issues that this panel was contending with was how to define what are standards of ethical conduct for House members, because the current rule did not give a lot of details about what that meant. So the first thing that would go on in this subsection B is to provide some specificity about what the panel means by House rules standards of ethical conduct. The first main substantive point would be in new B1A to say that a member shall respect and comply with the law, the House rules, and any other standard of conduct applicable to the member in the performance of the member's duties in a manner that promotes public confidence in the integrity of the House. And what that is getting to is the House is exclusively responsible for judging the qualifications of its members in order to maintain the integrity of the House. So the House overall is the judge of what really is acceptable conduct for House members in order to maintain public confidence in the integrity of the House and in the democratic process overall. This language in proposed B1A is similar to the U.S. Code of Official Conduct for U.S. House members. Also, moving on, it would be explicit in your rule in B1B that a member would need to comply with that candidate disclosure form, that legislative candidate disclosure form. That's not in your rule now. This would make it explicit that a member is required to comply with that statutory requirement for legislative candidates to file a disclosure form. What's going on in B1C is just moving up the language regarding that disclosure form. It's currently in Rule 14A, but it is related to ethics for all House members to submit their disclosure form at the beginning of a biennium. It's just elsewhere in the rule right now, and the panel discussed it seemed to make sense to put it all together in the ethics panel rule, so it's clear that completing that disclosure requirement is a standard of House member ethical conduct. And so there are no substantive changes to this language. It is essentially a cut and paste, except for where these forms get posted, because the current rule says that they get posted on the website of the General Assembly. Because this is a House issue, and because they're really now being posted on the House webpage, they would be posted there as well as on the clerk's webpage. And that's where they are right now. You can find the disclosure forms online on both of those case pages. Otherwise, what has to be reported in that disclosure form would remain the same. And then the rule just goes on. I'm on page 2 of the document. It's just more cleanup language to put all of the information regarding the panel itself. All of that would go under subdivision 2. So everything under subdivision 2 would all be about how the panel operates. So no changes until you get to page 3, where it says that the panel shall receive and investigate complaints of alleged violations of that new term, House member standards of ethical conduct made against members of the House, and may investigate such alleged violations on its own initiative. And that's just flagged for you as a point of further discussion in regard to whether that is appropriate for the panel itself to investigate on your own initiative. We can flag that for future discussion. Substantively, what's going on this page 3 in under subdivision C would be new ability, explicit ability that the House would be giving the panel to issue subpoenas. The House needs to issue to provide to the panel subpoena authority. This panel has discussed before that it felt the need to have subpoena authority in case it needed it in the future. You can't exercise it until the House gives it to you, since you are a subset of the House. There are statutory citations provided that describe why that power to subpoena needs to flow from the House, and that's also supported in Mason's. So the language right now is saying that the panel, by a vote of 2/3 of its members, can subpoena witnesses and documents as it deems necessary to conduct an investigation. And under C2, the potential rule revision will go on to say that in case there is the need for a panel member to recuse, or if there's an extended absence, the House Rules Committee could appoint an ad hoc member to the panel for that matter upon the request of the chair of the panel. That was just in case there was a recusal that was necessary, or an absence that would hinder the panel's work. Finally, you can see that what looks like new E about reporting the number of complaints filed, but that's just getting moved up from another place in the rule, just to put it under the panel duties under this subdivision. So it's just copying and cutting and pasting to here, that annual report. Retaliation prohibited would just get a heading designation. At the top of page 4, you can see that's where that panel report requirement was cut and just moved up to where we already described. And then the second instance of amendment here on page 4 is just repealing current House Rule 14A. That's the disclosure requirement, because that would be moved up into the panel rule. So that gives you a flavor of what the panel was describing before, for changes that the panel previously felt necessary to conduct your work.
So I'll now discuss some of the proposed changes to the procedure, if everyone has that in front of you. In that first subdivision 1, there are some substantial changes. First, you would strike the requirement that the complaint be signed. That would allow for complaints to be submitted by email or other method where signature isn't provided. You're also proposing to allow for the panel to make a complaint or for a complaint to be made by House resolution. You may want to discuss whether or not the panel should initiate complaints and how that might affect investigations. And the complainant may also submit additional information with leave of the panel, so that any subsequent information that the complainant provides isn't thought of as a new complaint. In subdivision 2, you're moving up the authority of the respondent to hire his or her own counsel from later on in the existing procedure, so that it is clear that it's throughout the process and not just at the hearing. Then you can skip down to subdivision 4A2. The panel already has ability to hire independent counsel for a hearing, but you wanted to give the panel the ability to have that independent counsel throughout the investigation. And then, as Betsy Ann referenced when she walked through the rule, there is the provision about the panel requesting information and potentially having subpoena authority to get testimony of witnesses and the production of documents related to an investigation. Then you can skip on to page 2. In the options, when the panel believes that there are reasonable grounds, you're adding a 4th option for action, and that would be to issue the respondent a confidential warning regarding the alleged conduct. It is intended to alert the respondent that the conduct might rise to the level of an ethical violation if it occurs on multiple occasions, and may provide suggestions for improvement when appropriate. The panel also would reserve the ability to reopen the complaint, and the conduct that has been subject of a confidential warning may later be used as the basis for a complaint if further complaints against the respondent are filed. And then there's some clarification in the stipulation about what happens if the respondent successfully completes all the terms of the stipulation. The complaint is dismissed if all terms are successfully completed. If they fail to complete material terms or conditions of the stipulation without just cause, it may result in the revocation of the stipulation and further disciplinary action in a separate underlying complaint. That then allows you to go to page 3. There is, under the findings, consideration of the fact that a respondent may admit that they conducted or had an ethical violation. And it also recognizes that if after a hearing or admission, the panel finds an ethical violation occurred, it will introduce for the House's consideration the resolution. And then going on to page 4, you've added a subdivision on voting thresholds for purposes at first of issuing a subpoena, issuing a confidential warning, or entering into a confidential stipulation. The threshold will be a vote of 2/3 of the members of the panel voting in favor of the action. And then for all other business, the threshold would be a majority of the panel voting in favor of an action. And then you add another new subdivision regarding amendments and special procedures. This procedure that we're walking through now may be modified, amended, or repealed by a vote of the majority of the panel. And when the interest of justice so requires, the panel, by a majority vote, may adopt special procedures deemed necessary to resolve a particular matter before it. And then the panel shall provide a copy of these special procedures to all parties in the matter. That gives you, basically acknowledges your flexibility as a body to set up the proper tools that you need for specific complaints. And so those are the proposed changes to the procedure.
And just to remind people, I mean, the panel conducts the investigation and a hearing. Ultimately, if there is to be a penalty, that is determined by the House in an open session. And the majority of the members of the House would have to vote for some form of discipline. So we can make a recommendation to the House as to that somebody should be penalized. It is ultimately up to the House to ultimately make that decision. And so be presented like a resolution. The party that's the subject of the complaint would have an opportunity to respond to it on the floor. And obviously there would be an opportunity for every member of the House to engage in debate and ultimately vote whether or not to censure or otherwise penalize the member that is the subject of the complaint. Go ahead, Brian.
Hi, this is Brian Chino, and if people are watching on YouTube, I have my video off, but I am paying attention, and I have a question at this point. it sounds like, once an ethics issue rises to the level of becoming public, like when if this panel in its confidential proceedings determines that it's going to move forward, it sounds like it's almost treated like other forms of legislation where there's a document written, it comes before the body has a public debate and then makes a vote. As part of the legislative process, there's a lot of behind the scenes work that happens with vote counting and calling. If somebody is subject to a complaint, is it within their right to reach out to members off the record and advocate for themselves and try to count votes so that the resolution will go in their favor? Like, is that because that's part of the democratic process normally, is that behavior considered allowable when there's a complaint against someone?
I can respond to that. From prior experience, yes, they can and they do. And they can hire their own counsel as the procedure recognizes, and that counsel can advocate for them. It has happened, and I expect it will happen again.
Okay, thank you. And I asked with no necessarily opinion on it. After hearing that, I do think, if any person is accused of any action, I do think it's fair that they have due process, and it sounds like we have due process here for them to defend themselves and make their case. And in the end, there is a public decision that will be made based on all of that. But I just wanted to know. So thanks for explaining.
I just to follow up, I think the rule and the procedure provides a lot of due process. The respondent gets the complaint almost immediately. They have ample opportunity to participate. If there is a hearing, they have opportunity to be there and be represented. And then before there's any formal discipline, there's another due process in the proceedings of the House. And as you noted, that might go through the full legislative process. And there you have due process there too. There's a significant amount of due process built into this process.
Any other questions?
Yeah, I have one.
Go ahead.
For 8 and 9, looking at the voting thresholds, can anyone shed any light on why it's majority vote rather than a higher threshold for 8B, 9A and B? I'm just wondering if that was drawn from another document or why that's majority versus a higher threshold.
I would just say that the exercise of subpoena authority by a legislative entity is a significant step, and to exercise that, you want to recognize the significance of that with a higher voting threshold. And then the majority threshold is generally, it's actually in statute. It says whenever there's a quorum, a majority is the standard unless otherwise provided. So that's just using the statutory standard for all other action.
And Brian, for your edification, typically the panel has acted by unanimous consensus with respect to any action we have taken. At least since I've been on the panel, everybody has always voted in favor of the action we have taken. And it's my goal to continue to follow that process as much as possible, because we don't want, the ethics panel should not be political in nature. It needs to make decisions that are in the best interest of the House and all of its members. So as I said, I think because we're so late in the session, trying to move these rules through the Rules Committee and voting them out of here would not be appropriate, especially because these are brand new to Brian. And I don't think it would be fair to push Brian to totally educate himself in the last 2 weeks of the session. So we will take these back up when we meet in the next session, if that is fine with everybody. If anybody has any concerns about that, let me know right now.
I appreciate that, and because I read this material, but I'd like to think about it some more. And if I had additional ideas based on the reading, will there be an opportunity at the beginning of the next, whenever we meet again, to just talk about additional ideas to any of the rule changes?
Absolutely.
All right. Thank you.
All right. So we're finished with that discussion. So at this point, consistent with our procedures, we are going to go off live stream to discuss a complaint, because any discussion of a complaint at this stage of the process is confidential.